Hello and welcome to Yada Yada Law School, a fake law school where real law professors teach classes about nothing for charity. My name is Greg Schill, and I am the Art Vandelay Dean and Kenny Rogers Roasters Foundation Chair in Business Law at the Yada Yada Law School. I'm also an Associate Professor of Law at the University of Iowa. We have a doubleheader today. We'll begin with Seinfeld Criminal Law, which will be taught by Professor Guha Krishnamurthi. Next, we'll have Seinfeld Civil Procedure, taught by Professor Robin Efron. Following each class, the professor will take Q&A. Please be sure to use the Q&A tool in Zoom to submit your questions. Now, all of us on the Yada Yada faculty are doing this strictly on a volunteer basis. We're doing it to help raise money for COVID-19 relief. Please be sure to chip in to our charity partner, Legal Services of New York City. We're closing in on our goal of $15,000, and so we appreciate your generosity in helping us get there. A direct link to the donation page will be added to the Q&A tool in Zoom and can always be found on our website, yadayadalawschool.com, or by Googling Yada Yada COVID Relief. Seinfeld Criminal Law will be taught by Professor Guha Krishnamurthi, the Japoco J. Peterman Chair in Jurisprudence and Fashion Design at Yada Yada Law School, a Klomenko Fellow at Harvard Law School, and Assistant Professor at South Texas College of Law. Q&A for this class will be moderated by Professor Robin J. Efron, Newman USPS Professor of Law at Yada Yada Law School and Professor of Law at Brooklyn Law School. Professor Krishnamurthi, over to you for Seinfeld Criminal Law.
Thanks so much, Dean Schill. I'm super excited for Seinfeld Criminal Law. As I said, I'm Guha Krishnamurthi. I'm the Jacopo J. Peterman Chair in Jurisprudence and Fashion Design at Yada Yada Law School. I'm also a Klomenko Fellow and Lecturer in Law at Harvard Law School for the next 9 days. And then I'll be as an Assistant Professor at South Texas College of Law, teaching criminal law and criminal procedure. You can reach me at Chichi Krishnamumu on Twitter for all things Seinfeld law and some cricket and chess. So before we get started, as Dean Schill said, we're doing this in conjunction with Legal Services NYC and really want to encourage you to donate to them. They're doing some really great things at a time when a lot of people need our help. So today on our agenda, I want to be talking about some foundations of the criminal law. And earlier in the semester, my colleague, Professor Jordan Carr-Peterson, talked about Seinfeld criminal procedure, and where he talked about kind of the ways in which cases get investigated and adjudicated. And this class is really about kind of the foundations of what the criminal law is. So to that end, we're going to be talking about theories of punishment, and then we're going to be talking about notice and elemental analysis. And with those in mind, we'll talk about how to design crimes and sanctions. And then finally, we'll talk about ignorance of the law and willful blindness as they arise in some examples in Seinfeld. And the episodes that I highlighted for today's class are the package from season 8, episode 5, and the finale. A hot take, I think these are both incredible episodes. I love the finale, and I want to hear your arguments otherwise. Okay, so what's the deal with the criminal law? That's my Seinfeld impersonation. So why do we punish people? So one reason is, to deter the person themselves from committing a crime again. We want to deter other people from committing similar crimes. Want to incapacitate a person from committing crimes. So suppose like a person doesn't get the hint, and is difficult to rationally deter. We might just want to prevent them from committing more crimes by incarcerating them. We also want to give the criminal wrongdoer what they deserve, right? And there's this intuition that people who do wrongs deserve punishment. And also, we might want to communicate to society what is wrongful. So these all get systematized into theories of punishment. But before that, I want to think about different perspectives on the criminal law. So there's the individual's perspective. And for an individual, they may think, this is a mechanism by which the state can impose punishment on me and therefore, control my behavior. The individual might also think, well, it's the same mechanism that can be used to punish others, including those around me, and so it controls their behavior too. And from this, we can level up to a kind of state's perspective, society's perspective. So it's, the criminal law is a mechanism to control the behavior of people in the state. It's a mechanism to ensure a just society. And, I want to emphasize here, it's a severe mechanism because the state can use punishment, which is the intentional infliction of pain on its citizens, right? So here we have a question of like, what justifies this? So that takes us to theories of punishment. To this end, there are sort of three theories of punishment that are, kind of well known in literature. The first is consequentialism. The second is retributivism. The third is expressivism. We'll go through each of these. So consequentialism is we punish for good consequences. That's the reason we punish. All right, well, you still need a theory of what those good consequences are. What are you trying to get at? And for this, utilitarianism is one example of a consequentialist theory. There are others, but this is one of the more sort of famous ones, where you're trying to maximize human happiness and well-being. Under this theory, you want to reduce criminality, right? Because that's bad. It causes suffering to others. But you also want to reduce the amount of punishment that you levy. That's bad too. That causes people to suffer too. The main ways we think about this are deterrence, right? We saw that earlier. You want to deter people, the criminal and other people from engaging in wrongdoing. Then you also want to incapacitate people. You want to say like, well, we're going to incarcerate you so that you cannot commit further wrongs. All right, so now let's think about retributivism. Retributivism is, we want to punish people to give them their just desserts, right? So what does that mean? Not those desserts, right? I love this line from Larry David, hey buddy, they've got a new invention. It's called a napkin, but not those desserts, right? So it's to give criminals what they deserve, right? And the intuition here is that, that when people commit a wrong, they deserve to get punished. So one example of this is you think of, let's say some criminal wrongdoer is convicted, but somehow escapes punishment for many, many years, 20 years. And then 20 years later, the authorities are alerted to this individual. And the question is, should they be punished? Well, let's say they're living a nice, fruitful life. They haven't, they haven't done any criminal wrongs again. They're sort of on the straight path. And you ask, is there a point in punishing them? And some people have the intuition, yes, they still should be punished. And another example of this is kind of famous example from the philosopher Kant. And that's if there was a deserted island, right? And they had a society and they were going to abandon the society and everybody was going to leave. They were going to go to different parts of the earth. Kant had the intuition that the criminals there in that society, they still should be punished before everything wraps up. They still need to be punished. And so there's an intuition that, wrongdoers have to be punished that motivates retributivism. But important for retributivism is proportionality because we don't want to overpunish, we don't want to underpunish. Overpunishing is also not giving criminals what they deserve. It's, it's not treating them with the dignity that they deserve. Okay, so retributivism, giving people what they deserve. Expressivism is this other theory. Sometimes theorists think that this is very similar to retributivism. Sometimes people think it's different. But the idea is we punish to express social attitudes, principally condemnation towards behavior. So these are three of the kind of most common theories of why we punish. So what's the underlying theory of punishment in our own criminal justice system? It's a good question. It's a tough question to answer. A lot of people think, a lot of theorists think that we're consequentialists about punishment. That is, we punish in order to get good consequences, but we have a limitation in that we do not punish more than a person's moral desert. So for example, we can't use an innocent person as a scapegoat in order to, alleviate people's anger at some wrong or something like that, right? So the idea is that we punish for consequential reasons, but we have a limitation in that we can't punish people beyond their moral desert. This is called side constraint consequentialism or negative retributivism. My own view is actually a pluralist view. I think that all of these ends, good consequences, desert, communication to society, they all matter and they all motivate our theories of punishment. All right, so I want to talk a little bit about notice and elemental analysis. So we've seen that, punishment is kind of unique in that the state is, it's a severe mechanism for the state to impose pain on its citizens, right, intentionally. And so, I want to start with this idea of the Blackstone ratio, right? And that's the idea that it's better to let 10, 20, or maybe even 100 guilty people go without punishment than wrongly punish one innocent person. It's a sense that punishment by the state should be restricted and people should really have notice when it might happen to them. So for this reason, what constitutes criminal conduct, it's got to be clear to the citizenry. At the same time, citizens are going to have an obligation to know what the law is, right? And so there's this Latin maxim, ignorantia juris non excusat, right? Ignorance of the law excuses not. And so we'll see that later too. So how do we ensure notice, right? How do we ensure that our citizens have the appropriate notice before they encounter punishment? Well, we accomplish this through codification and other doctrines like rule of lenity. So I'll briefly talk about the rule of lenity. That requires a court to apply sort of any unclear or ambiguous laws regarding the criminal law in a manner that is most favorable to the defendant. But codification is actually the real way that I think we safeguard notice. And codification is basically ensuring that criminal violations are enunciated in statutes that are publicly available and accessible, and so that people know they can just look at the penal code and they can determine what kind of conduct is wrongful or not. All right. So in a codification of a criminal violation, they use elements, right? A statute has elements. And what are elements? Elements are facts that must be proved to establish that one committed a crime. The elements together will establish requirements for the actus reus, that's the physical conduct, it could be an act or an omission required for the crime. Then there's the mens rea, the mental state required to commit the crime. And then finally, causation in some criminal statutes. All right, so best way to get at this is to consider an example, kind of a fictional example. So for those of you who remember Footloose, right, that was a movie in which the little town had a law against dancing, right? So consider a law against dancing in public. I just made this up, but it's, says an individual commits a violation when, in a public gathering, the individual intentionally moves one's body in a rhythmic manner to the accompaniment of music. All right, simple enough. So one way to start with this is kind of like, let's break down and figure out what the elements are. So I did this, so we have an individual commits a violation when, first, there's got to be a public gathering. 2, the individual intentionally moves one's body. 3, in a rhythmic manner. And finally, to the accompaniment of music. So along what we saw before, you see that intentionally is the mens rea here, right? That's the mental state required. And then the rest of this, you could say, are the actus reus, the physical facts necessary in order to show the satisfaction of this crime. All right, so we can ask, did Elaine violate this statute in the episode Little Kicks? And so in that episode, Elaine is throwing a party for her work, and she's trying to get the dance floor moving, and everybody's a wallflower. They're kind of like, I'm not sure if I want to get involved. And Elaine says, well, I'm going to start it off, right? And then we know what happens next. This is what happens. All right, so we can ask, did Elaine violate the statute when she did this? Okay, so first, look, it's a public gathering. There are enough people there. There's like 50 people or so, right? She definitely intentionally moves her body. So, that one's satisfied too, right? And to the accompaniment of music, yes, it's Earth, Wind, and Fire, Shining Stars. It's a great song. Okay, so next, is it in a rhythmic manner, right? Well, in George's words, sweet fancy Moses, no. Elaine's full body drive heave, her terrible arrhythmic attempt at dancing, did not violate the statute because, she didn't satisfy this element that it be done in a rhythmic manner. All right, so, I'm happy to hear counter arguments. I posted a little link, a little poll on the Facebook group asking whether Elaine dances or dances, whether she dances well, dances badly, or whether she's not even dancing. So register your complaint analysis there. Okay, so let's take a little less fanciful example. So this comes from the episode The Package, right? And it's mail fraud. Okay, so here's the mail fraud statute from the US Code, okay? And as you can see, it's very long, and we'll break this down systematically. But before we get there, so the question is, did Kramer commit fraud in violation of Section 1341 in the episode The Package? And, I'll just give you a little sum up of what happens. So Jerry, Kramer comes into Jerry's apartment, and he wants to use Jerry's stereo. He asks, stereo's not working, asks him what's wrong with it. And Jerry says, oh, it's fine. And then he gets a screwdriver, right? And he's prying at it. He's saying, this is what you got to do to fix it. Okay. At the same time, George takes a picture. All right. So Kramer asks Jerry, does he want a refund? Jerry protests he's not eligible for a refund. And Kramer just says, do you want a refund? Okay. Kramer actually just takes the stereo at this point, right? And Kramer's idea is he's gonna mail it to Jerry with insurance, and he's gonna let Jerry claim that the stereo was broken in the mailing. Actually, when it comes as a package to Jerry, he refuses the package, and actually Uncle Leo is the one who ends up accepting the package. Jerry finally gets it, okay, it's broken, right? And then comes this brilliant conversation with Kramer. Jerry is sort of perplexed. He's like, what, and Kramer says, oh, you can cash in the insurance. And they talk about, Jerry says, well, isn't that wrongful? And Kramer says, well, no, it's a write-off. It's a write-off. And they both admit to not knowing what a write-off is. And nevertheless, Jerry, they must have sought the insurance refund because they're flagged by Newman for mail fraud. Okay, so now we can look at the statute again, and I've kind of broken it up into these three elements here, right? And they're still pretty long, but we'll kind of we'll go even further through it. But as we said before, these three things have to be satisfied, right? They're elements that all of them have to be satisfied in order to show that Kramer violated the statute. Okay, so we can break down the first element further, and let's focus in on that, right? So whoever having devised or intending to devise any scheme or artifice to defraud or for obtaining money on fraudulent pretenses. And then there's this other option that has to do with, counterfeiting. We can dispense with that one because that one's not that one's not really relevant here. So the question is, did Kramer devise or intend to devise a scheme to defraud or for obtaining money on fraudulent pretenses? And the answer is yes, right? Because Kramer, what he's going to do is he's going to take a broken stereo, he's going to break it actually even further, and then he's going to mail it with insurance and then claim that the stereo was broken in the course of mailing, but it wasn't, right? So that's on fraudulent pretenses, and it's a scheme to defraud. So he satisfies that element. Great. So now we can go to the third element, right? Third element again in here is super long, right? But it kind of sums up to: did you place the package in the post office's authority in order to satisfy the scheme? And actually Kramer does do that, right? He does mail it to Jerry, and so this one's satisfied too. And then the next question is the second one. Well, did he mail the package for the purposes of executing such the scheme or the artifice? And of course, that's what he's doing, right? That's the whole purpose of mailing this thing, in order that it be discovered as broken so that they can claim the insurance money, right? So all three are satisfied, right? And actually, the statute says, well, you could be in prison for, not more than 20 years, but it's a pretty serious potential punishment. So, it seems pretty clear here that Kramer actually did commit mail fraud in violation of Section 1341. Funny enough, when Newman, flags the package, right, for mail fraud and informs Jerry and Kramer, Kramer just skips out. He says, "Oh, you're in a bunch of trouble, buddy," to Jerry, and he just escapes. So, now we can just ask, okay, well, so Jerry's in the hot seat. Is he in violation of the statute, right? And actually, Jerry may argue, hey, look, Kramer actually just took the stereo from me. I had no idea that this is what he intended on doing. And, I actually refused the package. I didn't sign for it, right? And in the course of the interrogation, a hilarious interrogation by Newman of Jerry, in which the bright light is on Newman and not Jerry, and Newman is sweating profusely. All of this comes up and blows up in Newman's face, right? Because Jerry didn't actually sign for the package. And Jerry says, I have no idea what you're talking about. And it seems like everything is stalled. But actually, what ends up happening is Newman, fixated on Jerry, he's just muttering Jerry's name. He walks outside and he sees a picture of Jerry with the screwdriver prying into his stereo, right? And this was at the 1 hour photo shop. And Newman confiscates these, and then he calls Jerry back in. He says, there's new information, right? And look, the big question here is whether Jerry had the requisite mens rea, whether he had the requisite intent to have violated this statute. And again, Jerry could just say, look, I had no idea that this was going to happen, right? Now, it's a little bit difficult because Jerry must have, cashed in the insurance policy to get this refund. But, we don't see that on screen. Now, the people who wrote up criminal codes, they kind of expected this sort of, thing, this kind of behavior, these kinds of like arguments in conspiratorial schemes. It's called the Ostrich Provision because, an ostrich buries their head in the sand, right? And so the Ostrich Provision actually says, knowledge of a fact is established if a person is aware of a high probability of its existence, unless he actually believes that it does not exist. So, the question here is, so whether Jerry is gonna sort of say, I had no idea, but then, kind of profit at the end, right, as the happy ostrich. And here, I think that Jerry probably satisfies the condition of having knowledge, right? Because he knows what's going on. Kramer is up to one of his schemes, right? He knows that he's not entitled to any kind of refund, right? And, furthermore, like he knows at the end of all this that, like, once they have the write-off discussion, he still cashes in the insurance policy, right? So, and then he has this exchange, with Newman. So he knows what's going on. So arguably, I think, Jerry does really satisfy the condition of having knowledge here. Otherwise, even if not, right, even if he didn't know about putting the package, he didn't have the requisite intent when the package was being sent, there's actually another code. It's called false claims for postal losses, and we can go through that later. But it's pretty clear that Jerry satisfies this one because he files for an insurance claim knowing that the claim is false. All right, so now I want to talk a little bit about how this law is designed, actually, Section 1341 in the episode, right? So, after Newman has Jerry dead to rights, Jerry asks, like, what's going to happen to me? And Newman says, it's a small fine, right? And I think we have to ask, does this make sense? Does a small fine really make sense for this kind of fraudulent behavior? And, I think we can look at the theories of punishment to get a sense of this, right? So consequentialism, before we talked about, deterrence as being one of the main good consequences that we really seek here, right? And so deterrent effect of a criminal law is usually understood as the apparent chances of getting caught, which I'll just refer to as P, and then the apparent magnitude of punishment. So we multiply those together. If you think that there's only a 1 in 100 chance of you getting caught, right, but you are facing 10 years, if you do get caught, well, that might still be a couple of months in prison, which is, kind of scary, right? That's the expected value. And so, I might think like, well, I don't really have any reason to engage in this kind of behavior. So here the P is low, right? Because Kramer thinks so. Kramer's, when he's pitching Jerry on this, he says, there's no way you're going to get caught, right? Jerry thinks so, right? Because, he has this exchange with Newman, right? Newman says, parcels are rarely damaged during shipping. And Jerry says, define rarely, and Newman admits frequently, so Jerry doesn't even think the Postal Service can engage in shipping packages, much less, ferreting out, the fraudsters. And Newman, I think, also thinks so. Newman also knows that the sort of lucky happenstance by which he was able to capture Jerry, right? He happened to be walking by a photo development place and saw this one photo of Jerry. What are the odds, right? So, the P is super low here. So you might think that the magnitude of punishment, right, needs to be pretty high to achieve some deterrent effect, right? So you might think there should be a really high fine. But in fact, here M is low too. It's just a small fine. And so the question is, does it even really deter Jerry and Kramer from doing this again? I mean, who knows, right? And sure enough, it's probably not going to deter other people if, in fact, the fine is low. But as we saw, in actuality, the statute has a pretty serious fine and a serious punishment for engaging in mail fraud. All right. Well, we can also think of this in terms of retributivism and expressivism, not just consequentialism. And arguably, the low sanction doesn't really give postal mail insurance fraudsters their just desserts. I mean, really, they're taking advantage of a societal good in this way, and we might think that's not really, people who engage in that kind of behavior, they really deserve more punishment. And you might think it doesn't really express our societal concern with manipulating sort of social goods in that way. But I also want to say, we have to be mindful about the dangers of overpunishment. We shouldn't overpunish. Overpunishment causes consequentialist harms, by causing needless suffering to those who suffer punishment. It doesn't give people what they deserve, right? We talked about that earlier. And it doesn't actually communicate what we think is wrongful either. So we have to find proportionality. And, I think incarceration is usually really not the right kind of solution. But, proportional fines, right? Not just a small fine, but proportional fines may be in order. Um, all right, well, now we can talk about the finale and Good Samaritan laws, right? So what happens in the finale, right? So in the finale, Jerry gets the good news that his show has been greenlit. It's come back to NBC, and so NBC offers the foursome a trip anywhere, right? And they decide, okay, we're going to go to Paris. And then Kramer engages some shenanigans on the flight, right? He's trying to get water out of his ear, and the flight goes down in Latham, Massachusetts, fictional town, right? And while they're kind of meandering in Latham, they see an individual get carjacked, right? Sort of apparently overweight individual get carjacked. And rather than do anything to help this person, right, they actually just mock him. And Kramer, all the while, is actually videotaping the whole thing. And Jerry has a cell phone, right? Because it's one of those Zach Morris huge cell phones, but he uses it just to call NBC to see if they can get on another flight. He doesn't think to call 911 or anything like that. So actually, funny enough, I remember when I was watching this thinking, oh, that can't actually be a law. Well, it is a law. There are Good Samaritan laws in lots of the states. And here's the one in Massachusetts. It's not the one cited in the episode. They cite a Latham County statute, which is fake, but this is actually the Massachusetts one. So again, this is kind of long, and we can break it down, right, into these three elements. So whoever knows another person is a victim of a crime, right, a serious crime, and who's at the scene of said crime, and then to the extent that said person can do so without danger or peril to himself or others, they should report the crime as reasonably practicable. Okay, so do these four satisfy the statute? Okay, so there's an armed robbery going on here, right? And actually, in the I believe that the person is armed, but actually, I'm not sure about that. So, but so there's let's just for arguendo say that the person is armed, right? And so this one is satisfied because they, Jerry, Elaine, George, and Kramer know that this person is a victim of an armed robbery here. Okay, so, and they're at the scene of the crime, right? And then to the extent that they could do so without danger or peril to themselves, they should report the crime. Well, did they do that? Actually, they didn't, right? Because they don't seem particularly perturbed, or they're not concerned about their own safety, right? They're just sort of standing there, and and they're kind of mocking this guy. And Jerry has a phone, right? He has a phone. He could call 911. He doesn't do it, right? And actually, they have no interest in reporting this at all. And then right afterwards, the officer approaches them and asks them, if they will arrest them, right, for not complying with the statute. So, I think they violate the statute, right? But, we can talk about the ignorance of the law issue now, right? So, it seems a little unfair because they didn't really know about this law, and it seems like a bizarre law, right? It seems like a bizarre law because it's not common, and also because it punishes omissions, right? It doesn't punish conduct. They're being punished for something that they didn't do, and they've just landed in a town. They didn't know they had to do this, and it seems a little unfair. So shouldn't that excuse them, right? Of course, this reminds me of the conversation that George has with Mr. Lippman when George is working for Mr. Lippman in the Red Dot episode in season 3. He has a romantic relationship with a cleaning woman, and Lippman, calls this to George's attention. He says, "Is that wrong? I didn't know that was wrong," or whatever. Great conversation there. So should that excuse them? Right? And as we saw earlier, no, because ignorantia juris non excusa, right? Ignorance of the law does not excuse people from complying with the law and from the punishment that might occur if they are not in non-compliance. So, I think we can ask, why do we hold people responsible when they don't know what the obligation is? And we could say here, Well, actually, they should know better, and that's part of their obligation and part of their failing too, right? So that's kind of a moral argument for why we don't really need to excuse people of these, just because they don't know what the law is. And with respect to this, there's this kind of interesting distinction in the criminal law called between malum in se and malum prohibitum. Malum in se is sort of like a thing that is wrong in itself. You might think of murder, theft, or something. Those are just like self-evidently wrong. They're wrong in themselves. And then malum prohibitum, which is wrong because society has said so in particular. That might be like driving on the right-hand side of the street instead of the left-hand or something. Those are sort of coordination laws, and there's nothing inherently wrong with driving on the wrong side of the street. It's only wrong because you've been society has said so. Right. So one thing is how that distinction plays in. The part here you might think, well, knowing to alert the police when you see someone in suffering like this, that's a wrong in itself, and you should just know better, and that's part of your failing, and that's part of your punishment too. Part of the reason that you deserve punishment. The other reason, the second one, I think practically more significant, it's we wouldn't be able to enforce the laws otherwise. People would just pretend, to not know the law, and what could you say, right? And so we don't want that. So instead, we kind of impose an obligation on people to know the law, but we also impose an obligation on the state to inform the citizenry too, right? And I think it's an important question, right? The state actually fails its obligation to these travelers, to these visitors, right? Because it doesn't tell them about any of this stuff. There are no signs, there's nothing like that. So you think about this, like generally too, are we satisfying our obligation is the state satisfying its obligation to its citizens and informing people about what's wrong? A lot of times people recognize, and we just saw it with the mail example, are so many statutes, right? Practically so many things are criminalized. There's so many statutes, and it's really, it's very difficult for anybody to know the code inside and out, and even have the potential to be able to sort of interpret them. That often requires really higher education and a lot of sophistication. So there's an interesting question about whether we are sort of satisfying that obligation too. So here you might think, well, Jerry Elaine, George, and Kramer, they satisfy the statute, but actually perhaps they shouldn't be punished. Yet their horrible performance in trial and the sort of like panoply of witnesses who testify to their sort of pattern of wrongful behavior probably did them in. One final interesting thing I'll point out about this is that the statute is actually the Massachusetts statute actually only has a $500 to $2,500 fine. So it's actually kind of a low fine for committing this violation. Yet the fictionalized one, the Latham County one, has up to a year in prison, which we know that the four spend together in a kind of hell is other people analog. So that's it. That's all that I have. I want to remind you again to support Legal Services NYC however you can. They're doing great work and mean a lot to us too. And finally, if any of this stuff interests you and you want to continue discussing it, you can find me on the Facebook group. I'm one of the moderators on there. And also you can tweet at me at GG Krishnamurthi. So with that, I think I'm happy to take some questions if there are any.
All right, well, thank you so much, Professor Krishnamurthi, for that. We have a whole bunch of questions, really interesting ones. So we'll start here. Is there a statute of limitations for certain crimes? Why do they exist and vary from crime to crime? For example, murder has no statute of limitations. That is in the question. That is not knowledge that comes from me.
Right. Okay. So why do statutes of limitations alter? Is that basically the question? Mm-hmm. From crime to crime? Yeah. So it's a great question. So the statutes of limitation are generally supposed to remove the threat of jeopardy from people, right? And so I think they exist in the recognition that the criminal code is voluminous, actually, and they're there are lots of things lots of behavior that we may engage in that may run afoul of some criminal violation, and that's not something that should exist over our heads, like the sword of Damocles, they say, hanging over your head in perpetuity forever, right? And so for lots of maybe certain kinds of financial crimes, like little sort of small criminal violations, there's a statute of limitations that sort of says, like, at a certain point, you should be able to, you're no longer deserving of punishment, right? And it actually doesn't make societal sense. It doesn't make consequential sense to punish you after a certain point in time. We're just gonna, let that one go. But with like certain kinds of crimes, you may think, no, that's actually not the case, especially serious crimes, the serious crimes of the person, like murder, and assault, and grievous assault and things. You might think, like, actually, those are so serious that we need, the state needs to be able to punish that kind of violation, even if it comes to the record late. Those are also the kinds of crimes which people spend meticulous, attention on covering up. The state is at kind of a disadvantage at being able to discover whether you've committed the crime or not. And to this, I'll just say one final thing, is that for lots of sexual assault crimes, there are statutes of limitations. And I think, there's a kind of a realization that many of those don't make sense. These are the kinds of serious, grievous harms that, if there's no statute of limitation for murder or for a grievous assault, why is there one for these sexual assault crimes? And so we're seeing some reform in that among the different jurisdictions.
Okay, great. So the next question is, sort of goes back earlier in your lecture. And the question is a public gathering, what does it mean? Is it a public gathering, or is it a private gathering that happens to be in public? And I will just editorialize and say, I think this is probably on a lot of people's minds these days, given where we are with COVID and restrictions and everything.
Yeah, so that's a great point. And I thought about that, and I kind of altered the language because I made that up. Yeah, there's a good argument that actually the public gathering issue, it really has to be in sort of like accessible to any people of the public, right? It can't just be a big party in a private area. One of the things, if you think about Footloose, right, is, I know we're going beyond the Seinfeld universe, but if you think about Footloose, the purpose of the statute there was really to stop like dancing, and like they might not want to have like a private gathering with tons of individuals dancing. That still may be something that they frown upon. But going back to the rule of lenity, right? That may be a pretty good argument on Elaine's behalf, even if she happened to have sort of rhythmic dance moves. She could say, well, public gathering here is vague, it's ambiguous, and we're not really sure how to interpret it. I'm the defendant, you should interpret it to my benefit. And I'll just say one thing, the rule of lenity is actually, it's not universal. Not every jurisdiction abides by it. Some of them just say, no, we're just gonna do our best to interpret it. But actually the rule of lenity seems to live in judges' minds. And so, we see arguments even in jurisdictions where the rule of lenity is actually not part of the code. They still seem to sway, they can sway judges' minds and sometimes jurors' minds too.
So I will just quickly note that the question asker broke in to say that even in Footloose, a permit was required. So thank you for that extra information.
Thank you so much, yes.
So the next question is also about this part of the lecture. So rhythmic manner seems to confer a great deal of discretion to the officer. Is this a void statute?
Could be, right? It could be void, because void for vagueness, because there are obviously different types of rhythms and different types of beats, and so it could be void in total. It could also, and if it's void in total, so goes my legislative drafting career. It could also just be void in any particular application, right? So somebody is actually dancing rather rhythmically, but they say that they kind of deliberately put a little hitch in certain steps to avoid the rhythmic manner, then an officer says, well, that's good enough. And you could say, well, that's just way vague, right? Like, so that particular application is no good either. So yeah, it could be void for both sort of like what they call facial reasons or as applied too.
Okay, great. So the next question is moving on to the package. And the question is, isn't Jerry an accomplice in the scheme?
Yes, right. So there are like so many different ways in which Jerry might actually be liable under the mail fraud statute. He's certainly liable for the sort of false postal claims thing because, even if he didn't know what was going on before, afterward, when he makes the claim, I mean, he must have made a claim for the insurance money. There, he's making a false claim, full knowing, all the after discussion. So prior to that, is he an accomplice? And I think maybe, right, he could be guilty of conspiracy. He could be guilty of accomplice liability. There are so many ways to build a case against Jerry, but all of them will require that he had the particular intent to commit the crime. And there's a place where the question is, when he first has the discussion with Kramer, he's like, how are you going to get this refund? Kramer says, I'll take care of it. Jerry doesn't actually know what he's going to do, right? And it seems like he actually only learns what he's going to do later. He says, wait, isn't this wrongful, right? Now, that's why I made the ostrich provision, the willful blindness sort of claim there, because, Kramer, so Jerry knows enough about Kramer's antics to know there's something not going, there's something not above board in this. And that's why I think, there's a pretty good argument that he satisfies the ostrich provision. But, so yeah, I think he could be an accomplice. He could be engaged in a conspiracy, but all of that will require that intent element. And I think the ostrich provision may be able to do that.
Okay, great. So the next question, is there criminal liability for a person who verbally taunts another, but not rising to an actual threat of anything coercive of that nature into committing a crime like robbery or murder?
Oh, I see. So the claim would, the thing is somebody, delivers sort of instructions and then therefore gets another person to commit a crime. Is that am I understanding it right? Or is this more a fighting word situation?
So, I did not write the question.
Oh, sure.
I suspect it's something along the line, like maybe the better way of thinking about it is some of the cyberbullying cases or other situations. I mean, the question was verbally taunting, but in my very limited experience, I've seen this come up in some of the cyberbullying situations.
Yeah, so it's a really good question, right? And I myself have some concerns, some First Amendment concerns and free speech concerns and how these kinds of things go. So, a statute may be defined to say, look, if you taunt or cyberbully someone into committing suicide, or if you sort of encourage them to commit suicide, knowing a kind of particular susceptibility due to their mental condition or mental state, then you could be guilty of a serious crime, right? And yet, there are some claims against that say, well, look, you're actually infringing on my free speech right to, tell this person what I think they should do or something like that. And so those haven't, to my knowledge, haven't been fully litigated, and there may be some live claims there. But, I say as in general, you take an analog, right? So if someone gives a bunch of instructions to someone, right, and to commit a crime, there could certainly be liability under conspiracy or even under, as we saw with the postal fraud statute, like if you cause someone to deliver the package or something like that, you can be liable too. And it doesn't matter that you don't actually engage in kind of like dropping the package, right? The giving of instructions to commit legal wrong is enough to ground criminal liability.
Okay, so we have time for one or two more questions. So I want to make sure that we get some in about the finale.
Yeah.
So one of the questions is, in the finale, the cop arrives at the scene of the crime immediately after the carjacking happens. So what would Jerry's reporting of the crime really have added? Is this legally relevant? I also have that question.
Yeah, it's a great question. And so we look at the statute itself, right? And we can ask, like, well, is there a requirement that, is there a requirement that if your failure to report is basically immaterial or doesn't cause any further harm, does that get you off the hook? And it doesn't look like the text of the statute does that, right? Now, one way of responding is to say, look, you ask, the statute demands that we report this as soon as reasonably practicable, right? And if the officer just comes within 15 seconds, right? I don't feel like I have to do anything. It wouldn't have been reasonable to demand that I report the crime, right? Like if there were 50 people, around, and the officer immediately approached the victim, would the 50 people be required to say, hey officer, like, no, probably not. So it could be relevant in the interpretation of what's reasonable and what's reasonably practical and what's necessary. But the issue here is slightly different. I mean, you might think like the four don't actually know that the officer will show up on time at all, right? Like they don't know that. They're actually caught off guard by the officer. They sort of see the officer and the officer tells them they're arrested. They're like, oh, you're here. So, like, could they have done something, in that moment? And if you look at that moment, I think there might still be some liability there.
Okay, so the last question, I'm actually going to kind of combine a few questions that people had about ignorance of the law. So there's just sort of some general questions about how ignorance of the law plays into the concept of mens rea. And then a more specific question, can counties write bizarre statutes like, quote, you have to drive while wearing black, and then expect people to drive and know this requirement?
Okay, so the first part, could you just repeat the first part again?
The first part of the question, there were just a few questions where
people
wanted to know the relationship between mens rea and ignorance of the law.
Okay, great. Yes. So, that's a great question. And so sometimes, the mens rea, like the sort of the intent requirement or, the sort of mental state requirement of a statute will actually explicitly say you must know what the crime is. This happens with some white collar statutes, right? Because there's a recognition that, there's like this, regulations on these kinds of things, environmental regulations, all sorts of things are pretty difficult. And if you know what the regulation is and you try to circumvent it, that's what's criminal, right? Like that's what's required of that criminal statute. So there, the mental state requirement in the statute may explicitly demand knowledge of the law. And sometimes people refer to that confusingly as a willfulness requirement, that you actually have known what the law is and that you violate it. In general, though, that's not necessary. It may just be like, take a homicide example, murder. You don't need to know that it's illegal to commit a murder. You just need to know that your conduct will result in someone's death, right? That's enough to ground the statute. So even if you were ignorant of the law, as long as you had the right mental state to know that your conduct would have a kind of relationship with the sort of prohibited result, right? That's enough to attach criminal liability. And that's actually fairly common with most of the sort of criminal laws that we know of, theft and all that kind of stuff. The point on bizarre laws, it's a really good one, right? So, can counties require, that you, dress in black while driving and, you think that there are some constitutional protections against this, right? So requirements of dressing in black may, they may run afoul of freedom of speech kind of requirements, for freedom of speech rights. So there may be some constitutional protections. The other kind of protection that we really hope for is the democratic one. We hope that people will say, right, these are crazy and they shouldn't exist. And so, that they will vote them down at the ballot box, or they'll vote people into office who won't enforce those kinds of laws. And, as we see, I mean, I'm sure you guys have seen those like sort of BuzzFeed things of, 20 crazy laws, that of course never enforced because they're, they're particularly, they're sort of wild and they don't make sense.
Okay. Great, thank you so much. Sorry to everyone else who was on the queue and we didn't answer your questions. Although I will say that one of the questions, does this law that was broken in Seinfeld only exist in Massachusetts? And if so, why do laws like these exist in some states and not others? So I will just say that that is more or less where we are gonna pick up next hour with Seinfeld Civ Pro. So I won't be able to address the criminal side of that, but I hope that everyone stays tuned. We're going to take just a few minute break, and then we will start very, very shortly with Seinfeld civil procedure law. Thank you.
Thanks, everyone. And yeah, feel free to get me at Twitter if you have further questions, and I'd love the engagement.